All right, good morning, everybody, and thank you for joining us this morning. We're going to go ahead and get started. Welcome to the second advisory committee meeting for the OLCC 2024 Cannabis Bill and Technical Rules Package. Again, thanks for taking the time out of your busy day today to join us. My name is Nicole Blase, and I am the Rules Coordinator for the Oregon Liquor and Cannabis Commission. A few housekeeping notes before we get started. Today's meeting is being recorded. If everyone could please ensure that your phone or computer is muted unless you are speaking at today's meeting. Only invited committee members will be a part of today's conversation. Members were selected due to their level of interest or position within the community. With that in mind, we ask that each of you serve as goodwill ambassadors to the discussion so that you may represent your constituency professionally. Please be courteous to other committee members so that we don't have multiple participants speaking at once. You may use the raise hand function in Teams, or if you are calling in, please interject when appropriate and we will call on you in order. Non-committee members will be able to tender comments during the public hearing and during the public comment period. Committee members, please state your first and last name when you make a comment. All right, let's get started. Today is Monday, September 23rd at approximately 9:03 a.m. Many of you are familiar with the rulemaking process, but for those of you who have not yet had the opportunity, or for those listening in, I will begin by saying a few words about rulemaking and the purpose of advisory committee meetings. The purpose of an advisory committee is to increase the public's involvement in the drafting and development of administrative rules. The Oregon Legislature, through its enactment of the Administrative Procedures Act, ORS Chapter 183, stresses the critical importance of the public's participation in policy development. Advisory committees are an excellent way to solicit input from internal and external stakeholders who are likely to be impacted by the development or amendment of agency policy and rule. Consequently, advisory committee invitees may include licensees, permittees, industry representatives, OLCC staff, members of law enforcement, local government, the public, local community organizations, small businesses, and other interested stakeholders. The purpose of having all of the members on this committee today is to hear from different parts of the industry and public health and safety partners. The Commission strives to hear from all interested parties. Our role today will be to explain the background and context of these rules and the changes that are being proposed in this package. We will provide facilitation to ensure that all committee members can provide input today. During this morning's meeting, we will seek your input on the proposed amendments to the 2024 Cannabis Bill and Technical Rules Package, with today's focus being on worker permits and license population caps. Under Oregon's public meeting law, this meeting is open to the public, and members of the public are free to observe our discussion, but may not offer comment. The agency will digitally record this advisory committee meeting and will produce and circulate a record of our discussion. However, because today this meeting is intended to promote the open exchange of ideas, we will maintain an informal atmosphere, and meeting minutes will record only the topics discussed and the main points made. We will move on to introductions. I will call on you to introduce yourself. When introducing yourself, please state your name and the organization you are representing. Again, my name is Nicole Blase, and I am the Rules Coordinator for the OLCC. If I could have any OLCC staff that are here today to introduce yourselves, please. I'll start with Amanda.
Hi, I'm Amanda Borup. I'm Director of Education, Health, and Policy with OLCC.
Thank you. Anybody else from OLCC? I see we have a few folks here. Patrick or Denise?
My name is Patrick Owen. I'm the Recreational Marijuana Licensing and Permit Manager.
Thanks, Patrick.
My
I'm
name is
Denise.
Beth Sykes. Oh, sorry, Denise. My name is
Go
Beth
ahead.
Sykes. I'm the Assistant Manager of the Marijuana Licensing Division and Marijuana Worker Permits.
And I'm Denise Byram. I'm the recreational marijuana licensing technician.
Thank you, Denise. Melanie?
Melanie Musial, Director of the Administrative Hearings Division within OLCC.
Thank you. Any other OLCC folks that I can't see?
Gary Wright, OLCC Marijuana Compliance Technician.
Thank you, Gary.
And I'm Rich Evans, Public Safety Director.
Thank you, Rich. All right, let's see. I will move on to the, oh, sorry, go ahead, Tristan.
And Tristan Blaylock, lead worker for the marijuana technical unit.
Thank you, Tristan. I'll
Good
move on
morning.
to the-
I'm sorry. One
I'm so
more.
sorry.
Nicole Mitchell, marijuana licensing technician.
Thank you, Nicole. Sorry, I had a little delay there. Thank you, everyone. I will start with the RAC members that I received an RSVP from, and then we'll see if there are anybody else joining us for the RAC, and then we will go ahead and get started. Let's see. Marissa Rodriguez.
Good morning. I'm Marissa Rodriguez. I'm with Nimble Distribution.
Thank you, Marissa. Ellie Niles.
Hello, I am Ellie Niles with Nectar Markets.
Thank you, Ellie. Jesse Bondacue.
Jesse Bonnecue, Executive Director of the Cannabis Industry Alliance of Oregon.
Thank you, Jesse. Amy Margolis.
Hi, Amy Margolis. I'm an attorney.
Thank you, Amy. Adam Foster.
Adam Foster, I'm the Chief Legal Officer with Silver Stem Fine Cannabis. Thank you.
Thank you, Adam. Lee Stewart.
Hi, Lee Stewart, a community member.
Thank you, Lee. Margaret Flershinger.
Good morning, Margaret Flershinger, Health Authority Medical Marijuana Program Policy Analyst.
Thank you, Margaret. Jason Lampman.
Good morning, Jason Lampman, State 3, micro-tier producer, small farms.
Thank you, Jason. Aaron Purchase. Alex Berger.
Morning, Alex Berger, attorney with Emerge Law Group.
Thank you, Alex. Those are the only RSVPs that I received, but are there any other RAC members that are joining us today? Wendy Minty.
Good morning, Wendy Minty with Can Experts.
Thank you, Wendy. Any other RAC members joining us today? All right, thank you, everyone. We will go ahead and get started on our discussion of the proposed rule language. I will turn it over to Amanda Borup to get started.
All right, thanks, Nicole, and thanks for joining us this morning. So we can go ahead and get started. The first change in the rules is going to be in the definition section. It's at the very end. Luckily for us, worker permit starts with a W. So the change in that definition basically makes a temporary worker permit and the worker permit, it defines them as the same throughout the rule. And then if there's no questions there, we can go ahead and just move into the next section, which is the application process. You're going to notice that the changes in that section start in section 5, and that is the per capita licensing. We do want to note that how we actually get the 21 and over population will come from Portland State University, but it's a little bit up in the air exactly how we're going to get that. So the actual date itself may change, but the concept will remain the same. And the concept, I mean, that we'll give notice prior to accepting applications and then give notice when we're no longer accepting applications. And the only reason for that is the statewide population data isn't actually broke down 21 and over. And so we're going to have to kind of finagle that a little bit with Portland State, but we'll be using like the actual population from the source. Does anybody have any questions about how per capita licensing will work? Okay, not seeing any. Oh, yeah, Adam. Oh, you're on mute. Adam, you're on mute. We can't hear you.
Sorry about that. It just seems like we're following the statute here, right? So it's fairly mechanistic in terms of just following the numbers that the statute told us to follow.
Correct. Yes.
Okay.
Yeah. The statute gives us basically what we can do, and then we just write the rules to like highlight how it will be done. So in this example, the statute gives us the per capita numbers, and then the rule talks about how we're going to notify people and things like that. Jesse,
Very good.
see your hands up.
Thank you.
Yep.
The big question I have is, what the time, like, because it doesn't explicitly state a timeline for when you guys would be accepting applications after you make the decision point. I was just curious if you had thoughts about what that might look like. Once you guys realize you have to accept new applications, what the timeline would be for someone to actually be able to submit one.
Yeah, that's a great question. And we would like to give plenty of notice so that people have time to get their things together and get ready to actually apply. And so I can make a note of that. Maybe we need to specify a little bit more, like how much notice.
Because that was my thought, is like, because, I think for the process to be fair, people should have the time to, raise capital, find whatever that process is, and so that a little bit more time would be better probably. And then the other question I had is, how will you guys be deciding who gets the application? Will it be done like alcohol? Will it be done first come, first serve?
So basically the way that it's written in statute is that we have to accept applications when the license number drops below the specified number. And then we basically have to keep accepting applications until we go back over that number. So when we go back over the number, we would notify the public again that we're no longer accepting applications. We should point out that there is no denial criteria for those applications that we receive in that open period. So let's say, for example, we'll use wholesale because wholesale is most likely to be the first license that will actually open. So let's say we're 3 below the per capita number. We accept applications. Once we license 3 people, we'll close, or 3 businesses, you know what I mean? We'll close the applications. But if we received 40 applications in that period of time, we'll have to process all of those.
Even if that means not issuing 40? Or you'd have to accept 40?
We have to process them. If they're eligible, we'd issue them a license. And since before I go on, I see you have your hand up, Alex and Jason, but real quick, Jesse, just to follow up on your notification, like how much time would be appropriate in your mind to notify people?
I actually think the licensee should answer that question more so than me, if there's anybody who has an opinion.
Okay, well, I'll go to Alex next with his question, but then maybe when Alex is done and Jason's done, we can kind of open that up. Alex?
Well, I have a couple of different comments about the rules, but now I want to clarify because I don't understand. So for the wholesale example, 3 wholesale licenses open. OLCC opens the ability to apply, and then the applications go until the first 3 licenses are issued, and then you process all applications afterwards. So there will be 43 potentially licenses.
Correct. Because there's no denial criteria for the applications received when the window's open.
And OLCC you feel that OLCC does not have the discretion to impose a denial criteria?
that's not the way that the bill was written. So, and that's why we sent a copy of the bill too, just in case people would be curious about this. It wasn't anticipated, but when we were working on the rulemaking, we realized that we couldn't establish, there's no denial criteria for those applications received when the window's open.
Okay. That's interesting. Okay, so I just have some comments on the rule language in 5A. I think it makes sense to include some sort of language that specifies that the caps are subject to the exemptions in the following rule. Just because this seems to state that, there are these caps on licenses starting January 1, 2025, but there are, those exemptions that are listed in 845-025-1131-4. So I think it makes sense to include, subject to the exemptions in yada, yada, yada. Does that make sense?
Yes, it does.
And then in 5D, I think the language should state, if the commission finds the number of active licenses for any license type does not meet or exceed the per capita criteria, right? Because once the per capita criteria is met, even if it's not exceeded, license applications should not be accepted anymore.
Okay.
That's it.
Great, thank you. Marissa, I see your hands up.
I remembered to unmute myself. Back to an earlier question about the timeline. And I would campaign for 12 months. It sounds like potential applicants wouldn't know until you announced it. There wouldn't be a way to anticipate that there is the potential of licensing opening. And it takes quite some time to figure out where you're going to go and to raise the money to do it.
Okay, thank you. I don't see anybody else's hand. Do any other licensees on the rack? Oh, Jesse, there you are.
This is very question, just so we have a full picture of the situation. Do you currently have any estimates for like processing or wholesaling, like how close we are currently to the limits or the per capita ratios currently?
I don't right now, because we haven't looked at the 21 and over population. But I think the assumption is that wholesale would be the first license that would open. And that's just based on our estimates back in 2024 legislative session. But it wouldn't be, just so everybody knows, like, this is not going to be retail. This is not going to be producers for like many, 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 many years. So the only probably would be wholesale and processors at some point. Okay. So do any other licensees that are on the rack have any feedback on like how much lead time we should give as far as like letting people know that the applications are going to be open at a certain date? Jason?
I agree with Marissa that it does take a long time, but I don't know, I'm all for even just open licensing, but I guess to play the devil's advocate against my own self, I would say that if you leave licensing open, we have to remember that every license will be processed then. That information you gave is really a interesting piece. So if you left it open for a year, potentially every person that applies would get a license.
Oh, so I was thinking that, well, Marissa, correct me if I'm wrong, was thinking that basically we notify people that that we will open the licenses, and then we notify them, and then like we say, let's say if it was today, for example, So September 23rd, 2024, we say on September 1st of 2025, we're going to open these licenses. Is that what you meant, Marissa?
Like, yes, and I think there's also like an adjacent conversation that maybe we can have sometime about just timelines for everything. And then and I'm thinking about geography, like a property being associated with a license, with the way that current licensing and is, but I don't know if that's appropriate in this conversation. But I don't know that I'm advocating for the window to be so long, but or for the notification to be so long, but for the timeline between any sort of notification or understanding that there's an opportunity, and then the deadline to get it all done, just because I understand how difficult it is to find a property, and raise money.
Okay.
Yeah,
And
that
Jason?
okay.
Yeah.
I agree. Yeah, like I agree 100% with that. It takes, especially for a small business like ours, to raise capital and find a property has been so hard, even just lately. So I agree. Yeah, I agree with Marissa. Thank you.
Okay. Alex?
There is no deadline to get it all done, right? I mean, the deadline is once the licenses are issued that make up the cap. Right, Amanda, if I understand correctly?
Yeah, the applications, we would accept applications until we went back over that per capita number.
Right. So it's a matter of how quickly the number of licenses that are actually open, and then how quickly OLCC processes all of them once the application window is open, right?
Yep. So it would be like, for the wholesale example again, with the 3 licenses, right? So we would keep that application window open until we had issued 3 licenses. Then we're at the cap. Then we would notify the public that we're no longer accepting applications. And then we would just, obviously, like I said before, continue processing those applications that came in during that window.
Right. Okay. And then an application will be processed if the application fee is paid, or what constitutes a completed application?
And anybody from licensing can jump in here, but all the other rules apply. So this is no different than any other application. And I see Patrick jumped in. So perfect.
So yeah, the criteria for what is considered a completed application is already encapsulated within rule. It's submission of all of the required documentation. The application fee, of course, is part of submitting an application. So if those criteria aren't met, then the application would potentially not be considered submitted. But that's rarely a problem. Most applicants provide everything they need to submit the application, and as long as they're paying that application fee, we're moving them along through the review process.
Okay. So the last thing I would say is I would encourage OLCC to think about, I mean, the licensees know better than me, but a 12-month period to get ready to apply for licenses, that could greatly increase the number of applications that actually get submitted, and ultimately processed, given that all of them will be processed until the first however many licenses are issued.
Okay, so Jesse, you're showing us hand number 1. We'll just go in order. Wendy, you're 2, Amy, you're 3. So Jesse, go ahead.
I was just gonna reiterate sort of the deadline that Marissa was referring to is the ability to start actually submitting an application to the OLCC, and that being the 12-month window. And then, yeah, as Alex pointed out, but then there is this sort of no deadline until except for when you guys process the 3. But that initial window being broad is probably appropriate. And then, as the person representing a cannabis trade association here who can, have some effect in the legislature, I am taking note of your guys' assertion that the OLCC doesn't have the authority to stop processing applications until, they're not accepting them, and sort of that there's an unanticipated consequence that we should probably fix as soon as we can if that's what the industry wants. So I heard that loud and clear from people that there's a concern, and just want to flag that there might need to be a legislative fix for this, that the OLCC can't pursue itself.
Right, thanks, Jesse. Wendy?
Yeah, just to agree with what Marissa's saying, there is kind of a double-edged sword there. I mean, time to secure a location, build the capital, be ready for when your application gets assigned. A 12-month lead up of course would support the licensees on that back end. However, we're talking like best case scenario at minimum 60 days for 3 applications to get approved. And that's like best case scenario. So 60-day window for however many more complete applications to come in the door. And then your no denial criteria requires you to approve all of them. Is that how that's lining out? Because that seems like there's going to be a floodgate again.
So my understanding, Amy, I'll come to you next just to make sure I'm understanding this here. So we're talking about basically OLCC saying that we're going to start accepting applications at a certain date in the future. And then at that date in the future, people can apply. And they can apply until we've issued a certain amount of licenses to go back over the per capita number. And then we close it, so we don't accept any more applications, but we would process everything that we received when the window was open. Yeah, okay. Amy?
Hi, thanks. I mean, I just want to make sure that I am following, and I have to admit I'm dealing with a couple other things over here. I mean, it could just be like 1 or 2 applications that open up, right? I mean, it doesn't have to be like a huge mass. Like, it's not like 100 applications open, right? It still stays within that population control number, right?
Yeah, so basically we'll use a wholesale example again. We have 2 licenses under the per capita amount.
Yes.
So we would accept applications. Once we issue those 2 licenses and we get back to the cap, we would close the application window.
I got it. So that's what I thought was happening. So, I mean, in that scenario, we're talking about like sort of like it's like just a race to be one of the 1 or 2 or 3 people who might get an application, unless there's some sort of statutory change or more direction from the legislature. So like, we're not necessarily talking about the, open applications open again. We're talking about that you're filling the per capita number that is permitted. So that could be a tiny number, that could be 5, that could be 7, it could be whatever, but it could just be 1 or 2. So kind of whoever first come, first serve gets theirs in, unless there's a statutory change, you'll issue those and then you'll close. And then what will happen to the licenses that were submitted will they just like sit in the queue for the next time the per capita opens up, or they just forfeited their application fee and off they
No,
go?
we have to process those. We don't have denial criteria.
When you say you have to process them, but what if it goes over the cap?
So Patrick, you look like you want to chime in. Feel free.
Yeah, I feel there's some clarification needed here, and Amanda, correct or stop me if necessary. But the language within the bill prohibits the commission from accepting applications when we are over the cap. So when we're not over the cap, we must accept applications. What Amanda was saying earlier, and again, correct me if I'm wrong, Amanda, is that we don't have a denial basis tied to the cap. So we must accept applications whilst we are beneath the cap. And once we are over the cap, we may no longer accept applications. But we will have already accepted those applications. So it's not that if we are 3 licenses below the cap that we will only issue 3 licenses. It's that while we are under the cap, we must accept license applications. And therefore, once we have those, even once we have closed the window of accepting applications, we must still process those applications, applying our existing approval or denial bases to those, which does not include the population cap. So the implication then is that all those applications that come in during the window potentially could get approved.
I mean, that's like a drafting problem, right? I mean, this was something that went wrong at the legislature that could have or should have been caught at some, I mean, not saying it to you, I'm saying
You are more than welcome to make that comment.
Yeah,
I can't speculate.
that is my personal feeling, is that that's some sort of error that needs to be fixed, some sort of unanticipated consequence. And I mean, probably, if there's a cap and the bill language permits going over that cap, I think you have like an inherent internal contradiction. So that's not up to me. I'm not doing the lobbying, but February session appears to be right around the corner. So.
All right, Jason.
I just wanted to bring up the point to calm some of the fears too, that when we were in the last rack, I believe they said that a lot of those rules were to stop businesses from parking licenses. So I think that there are some protections already in there. I'm not exactly sure how transfers go and everything, but I don't believe you can move it. So you would have to have a place and have it be there. So the rush that was the previous rushes that we have where people were just getting licenses and then moving them after the fact, I don't think that's possible anymore. Thank you.
Yeah, thank you. All right, I think we can move on unless there's any further comments on this section. All right, so then the next section is the fees. I believe we might have had this at the last rack, but it basically changes the fee for the worker permit application to be at the time of application rather than after. Marissa?
Does that mean if someone were to be denied a worker application that the fee would be refunded? No.
Jesse, well, actually, Patrick, you shook your head no. I think it's a non-refundable fee. Somebody from licensing is going to have to help me out here.
It's not specifically defined as refundable or non-refundable.
So we'll make a note of that. Right, and Jesse, you had your hand up, you put it down, so no more questions there. Or yeah?
Sorry.
You're on mute, Jesse.
So this is Jesse from the CIO. Just as a point of clarification, wanting to confirm what we discussed last time, but that, at the time of application, people are getting temporary, like they're not paying the $100 and walking away without the ability to work in the cannabis industry. They are getting a temporary permit at that time, right?
Yeah, correct. And we can just go ahead and move into that section because that's next.
Yeah. So that was my big concern, was just that, if you're charging people $100, you should make sure they can work right away and not charging them until they have the opportunity to work. I understand if they we could debate whether people should, be refunded if they end up not being able to actually pass the criteria. But like, at least for this initial thing, I think it's just important that if they're paying the thing, they have the ability to go get a job and aren't waiting for processing.
Yep, and that's the reason for the change.
Yeah.
Okay, so then we go into 5520, which is the worker permit language for the temporary worker permit. Alex?
Are we skipping 1131?
Oh, shoot, did I? Sorry, hold on. Let's go back. 1131. Oh. Yep, and that's just basically, that's a cut and paste from statute. And I believe that was the area that you said that we should link to in the first part that basically talks about the exemptions.
Yeah, I still also have some questions and suggestions.
Yep.
So first, it seems to me that subsection 4 should state section 2 and 3 of this rule do not apply to those lists of exceptions. Is there some reason why license applications submitted between March 31, 2024 and December 31, 2024 should not, like, change of ownership applications that were submitted should not still be processed?
So 2 is basically saying if you apply during that period of time, your application will be inactivated.
Right, but is that true of change of locations, renewals, and changes of ownership?
This is Patrick Owen, OLCC. Alex, I see what you're saying. Thank you for the comment pointing that out. So the intent is not to inactivate valid applications for other types, for change of ownerships, change of locations.
Okay. And then I was just going to ask again, I think this might be drafting issues, right? But 4B, like, there is no OLCC sort of process or term of art for a change of ownership of a facility or premises. So, I mean, I imagine the intent of that language in the legislation is to maintain the ability to submit a change of ownership or change of location application. And so if that's correct, and by the way, that D4D, the sale or purchase of a license issued prior to December 31st, 2024, doesn't make any sense because you can't buy or sell just a license, right? Because they're unalienable. And the idea is that you are buying or selling a licensed business, right? And so it would seem to make sense to, in 4B, state something along the lines of application for reissuance of a license necessitated by change in the location or ownership of production, processing, wholesaling, or retail facility, premises, or business, I think. Because I think that aligns with change of ownership language generally in the rules. Yeah, and then there's no need for D, which doesn't make sense anyway. Does that?
But it's in statute. So.
Yeah, but yeah, I suppose you could leave it in there, but it just would not affect anybody or mean anything. But
yeah, I mean, it's there, so I think we need to be inclusive of what statute is.
Okay.
But thank you.
Yep.
Jason?
Hi. In 1131, in the list of exemptions, section 4 says this section 3 of this rule does not apply to section 4 C, an application for a change in size of mature marijuana plant grow canopy. I'm not sure if it matters, but possibly you'd want to include immature plants as well, since there is a micro-tier endorsement for to be able to add immature canopy that I was actually planning on possibly utilizing in the future. So maybe if, I guess, Mr. I forget his name, Owen would know better, but I would like it so that we don't have to, so that we're exempt on any kind of adding any canopy that is within statute for the micro tiers. Thank you.
Yep, thank you. Alex, your hand's up again.
Okay, yeah, thanks. So I just want to clarify then, again, in terms of the sale or purchase of a license issued prior to December 31st, 2024. So is it the OLCC's position that now I can advise my clients that you can buy and sell licenses only, and you don't have to go through the rigmarole of an asset purchase agreement for additional assets or a share purchase agreement, and you can buy and sell any license that was issued prior to December 31st, 2024?
Patrick, go ahead.
I don't think we can advise you what to advise your clients on, Alex.
Okay, but the statute says what it says and the rule says what it says, obviously.
Yes, there's still language within statute that reads that a license is not transferable except as, and I'm not directly quoting the statute, but except as part of a change of ownership following all of the requirements for that process. So reading those two in context, I think, might lead us back to the process for doing a change of ownership still includes all of the requirements for a change of ownership. And that's how we would be processing those from a licensing standpoint.
Okay, Jesse? You're on mute.
Jess Bonacue from the CIO. Sorry for being on mute. I think this is another place where I have flagged that there might be need for some legislative work and a legislative fix to clarify some of the language and make it cleaner and more direct. But hopefully we have the time to do that and the ability in this coming session.
Okay, thank you. All right, we're ready to move on to temporary worker permits. All right, let's go. So that's down in 5520. Give everybody a second and we can see if anybody has any questions or comments. Anything on the temporary worker permit section? Okay, we can continue on then. 5540 talks about the denial criteria. Okay, we can go to the next section. Let me know if I'm going too fast or if you guys want more time here. 5560. Right, there was no changes to 5580. We just kept it in, so it was the full rule almost. 5590. Okay, Alex.
Thanks, Amanda. I just wanted to make the comment that I have had many clients who have been experiencing issues with their worker permitted employees misappropriating funds and not wanting to report it because they would worry that they get dings on their own licenses and that there's not something in the rules that would allow OLCC to suspend or revoke a worker permit for that purpose without a conviction, which may never happen because the police don't always respond or do anything in these cases. And so I would propose an additional suspension or revocation subsection that states something along the lines of the commission shall suspend or revoke the worker permit if the commission finds or has reasonable grounds to believe the marijuana worker has misappropriated marijuana items or funds from a licensee.
Melanie, go ahead.
Hi, Alex. So there was a section about in our last rack, there was a section that covered what you were talking about. I'm still working on to finesse that section, I guess I'll say, based on comments that were made in the last rack. So what you're talking about is in, I think it's 8520 or 8540. There's a section about that. It would not be in this one. It would be in the 8540 or 20 section. But we are looking into addressing your concern there.
Thanks, Melanie. All right, any other comments here? Okay, that takes us to the end of the document. So again, thanks everybody for joining us this morning. And I'll let Nicole do the closing.
Thanks, Amanda. And yes, thank you everyone for joining us. In the email that I sent out with the meeting materials on September 17th, there was the fiscal impact statement questionnaire. Did anybody have any feedback or possible fiscal impacts of these changes that they would like to tell us about for the record today? All right, well, you will have ample opportunity to submit that if you, after today, decide that you'd like to submit some more feedback. You can submit that or any other feedback for the permanent rulemaking record at olcc.rulemaking@olcc.oregon.gov, and I will put that in the chat as well. Adam, you have your hand up.
Hey, thank you. Sorry to kind of be a little out of order, but if we're circling back on the license cap point, I did just want to point out, I was looking at the statute, and in section 19, and this is the 7,500 or 12,500 caps, but I see that it does say OLCC may not accept applications for a new license unless, and then we get into the population criteria. And then it goes on, and in subsection 2, it talks about the OLCC may delay processing, approving, or denying only if various criteria are met. But I guess I just wanted to point out that in my mind, that doesn't in the statute firmly answer the question of whether the new licenses, if you get more applications, so let's say the ratio would indicate that 3 wholesale licenses are available and you get 7 applications. I guess I just wanted to point out that in my reading of the act, it doesn't clearly answer the question of whether at that point you have to issue 7 if 7 qualifying applications have been submitted, or if the ratio would imply that it's only 3 that should be issued, if you could go ahead and cap it at 3. And what I'm looking at is, again, in section 1, that may not accept language that sounds permissive. And then at section 2, it's only really talking about approving or denying and processing. And so, I would indicate that there may be a little bit of discretion that's available to OLCC in the statute to decide if, when the 3 is hit, if you want to stop there, or if a license must be issued to everyone who submits a qualifying application.
Yeah, and I think the issue is that for those applications that were received, once we hit the per capita licensing number again, we wouldn't accept any more applications.
Right.
But those applications that were received, we don't have a basis to deny those based on the license caps. They could be denied for other reasons that we have a basis for denial, but they couldn't be denied just because we had reached the license cap.
I hear what you're saying. I mean, respectfully, I think the discretion may be there, but I also think that if the way the OLCC is reading the statute is every qualifying license should be processed and granted, I think that's also within the OLCC's discretion. So I have a slightly different view in that I think either the way I'm reading it, either interpretation would be permitted.
Okay, thank you.
Thanks.
Thank you. Is there any other feedback before we conclude today? All right. Well, on behalf of the OLCC, I want to thank everyone for their contributions today. I did put our rulemaking email in the chat. So if you have any additional feedback after today, please feel free to contact us. A notice of public hearing will be issued subject to change, but the target will be November. So November will be the public comment period and opportunity to provide testimony as well. But if you have any questions in the meantime, please feel free to reach out. So thank you to everyone again, and have a wonderful rest of your day.